Thank you so much for the invite to London. Before I get into my talk, I want everyone to consider the concept that our digital lives are not separate from our lives. Just as I go through my talk, I want you to constantly hold that concept near and dear. So before I get into any of the talk, though, I think it's necessary to define personal data. There's a relatively long description up here, which is a bit more elaborate than how most data commissions define personal data. But about 10 years ago, when multiple of us activists and people in government and people in business started making submissions to the EU, very specifically to the Irish, we were trying to define what personal data is to write more regulations around it. And to oversimplify what you see on the screen, I'd like to establish that personal data is everything that disseminates from you and everything that is derived about you. Everything. I like to think as everything that is not personal data as a derivative. Think about it as a financial derivative contract of personal data. It is always compelled by input from an individual or design exclusively from an individual, which is also, again, input. So before we tumble down the rabbit hole of how Americans are thinking about and how American markets are thinking about personal data and GDPR, I think it's necessary to establish what personal data is, sort of give some definition to it. With that said, my name's James and Felton and Keith. I have far too many first names, so most people just call me JFK, but you can call me J or JK or James and Felton and Keith, or really anything you please. I run the data union. Before the data union was the union, it was the International Personal Data Trade Association. So we're a trade association mostly of insurers and technology companies that sought to establish and push policies around, again, what personal data is and the like. And GDPR has surely been a result of that. We've participated heavily in think tanks and submissions across the board in the EU with regards to how this particular regulation has been established. So we're really excited about it. I myself am extremely excited about it because we see it as an entry point to where we're going. I feel like May 25th was the beginning of the 21st century. That 18 years before that, we were just sort of nostalgic about what the 20th century was and what products and services looked like. But now we are here. So I guess to further give context to where we are before I do a deep dive into how the GDPR is a catalyst for data ownership in the United States and really everywhere as a result, I like to establish the rhetoric that we're hearing around this new sort of data industrial complex. I think Mark Zuckerberg came out a few days ago and said that he is excited to see legislation like the GDPR in the United States. So many other people are talking about that. Tim Cook is who, if you're not familiar, is the CEO of the largest company on the planet, Apple Computers, has taken a very broadly stance at calling out his competitors, or rather his peers, to say that they are using your data to manipulate you, et cetera. And the rhetoric is, in my opinion, a bit dire. And it's used in a warlike structure, and I think as a result incentivizes the wrong sort of interaction with personal data, which again is sort of evidence of our personhood, digital evidence of our personhood. But in thinking about that, I think we must think about potential fearmongers as everything is becoming data. So everything that we know about in the physical world, everything that we deal with, we have some sort of digital representation of it. If we don't, we're moving towards that mainly because we can't assess risk without that evidence, so to speak. And so with that in mind, I'd like to be a bit more philosophical and establish that we're living in this age of knowing where, I think I heard somebody earlier giving a talk far over there in one of the other sessions about us being in this information age. And I think it's necessary to establish we are far beyond the information age. We know what information is, we know where it is, we know how it is, and all of our jobs, if we have jobs in the room, is probably specific to building a pipeline to that information. So we know what data is and where it is. We're all just working on how we establish a constant flow of that information going forward. By 2025, our population will have grown past 8 billion people, and the amounts of data that we create, which is now about 2.5 quintillion bytes per day, will far exceed the fathomable, idea of what a data point is. And this is all before we even get to using 5G. I know in the States we have some places that are using 5G to, help data proliferate, but it's not a reality worldwide yet. So we're living in this relatively new time. It is an extreme paradigm shift, and the GDPR is a derivative of that. But again, the rhetoric, especially here in Europe, but that's not to say that Europe is alone. The United States is right there with you. And talking about data from a standpoint of privacy, they talk about data from a standpoint of surveillance, as if Big Brother, not necessarily the governments anymore, but now Google, like the firm who just got off the stage, is endeavoring to reverse engineer your general lives in the zeros and ones. And the reality is that already happened. That happened about 20 years ago. So when we talk about data and data proliferation, I think usually the term proliferation is used with regards to nuclear war and nuclear proliferation. I want to draw your attention to the idea of data proliferation because it is very dangerous if we continue to talk about, from a political standpoint and as business leaders, from a business standpoint, about data as this inherently dangerous thing. We can endeavor to make sure that data proliferation is a prolific thing. I think the upsides are radically pleasant, for lack of better phrases. So that being that, we are endeavoring to, at the Data Union, engage governments and industry to come together to figure out how to communicate to the general population about how valuable their data is. And I say that, I want you to keep that word in mind, that word value, because I myself, as the leader of the Data Union, and I've founded multiple companies in the space in fintech and insurtech and ad tech that are specific to data, and I'm not a privacy advocate. I do know that privacy is important, but I think it is secondary to the idea of how valuable your data is. And so while the GDPR is very specific to how we protect you, the language that we use around here at this conference and most other places is very specific to privacy, but protection is not a privacy thing. Protection is something, and security itself is something that we do in caucus. Humans have always been a tribal species, and we've always seen ourselves more prone to living well when we come together, not when we draw lines between us to, say, become more private. That is not to say that we shouldn't have agency over who gets to know what about us when. And so as you can see via the firms outside, there are a lot of new tools in play for how we control our information and how we control the distribution of it back and forth between entities that may care to know more about us as they endeavor to provide more products and services to us. But specific to data proliferation, I think it is necessary to invoke a sort of spirit of data positivity, because what we get to understand as data proliferates is what minority classes look like. And I'm not just talking about gender and race and you name it. I'm talking about the difference between someone who lives in a rural area versus someone who lives in a urban area. The difference between someone who spends a lot of money on consumer goods and someone who doesn't. The difference between someone who's older and younger. All of these classes of individuals pose certain risks. Risk to their longevity, risk to our overall community, risk to our society. And as they do, industry, not necessarily the technology industry, but the insurance industry and government have a vested interest in incentivizing not only more data to proliferate, but also do that while communicating to the public that they do have agency over what they contribute. And so that brings me to why the majority of us are here. Early days when the GDPR started, well, when early writings of the GDPR started, I think, and it's a bit of a fluid process, but I think after there was a large big data symposium in New York that I remember around 2009. That wasn't even 10 years ago. I think most people outside of our circles, when I say big data to them, they've never heard that prefix on the word data. that event happened, and then I remember at the World Economic Forum, a lot of folks were talking about data as an asset class. As those two events started to change the rhetoric with which we regard data, new language started to be solidified in the GDPR. And a lot of people see the GDPR in a lot of different ways, but I'll tell you from the value advocate, from the business person's perspective, I always saw the GDPR as a compromise. There were governments looking to establish a broad sweeping cybersecurity regulation with which they could hold corporations accountable who were amassing a large wealth of data about all of us. And then there were economic advocates who cared more about these three human rights that were written into the GDPR. So I look at the GDPR and most cybersecurity laws as a way to enforce digital human rights. To go back to that first thing when I mentioned, or excuse me, that I mentioned when I stepped on stage, which is that our digital lives are not separate from our lives. And so, as most of you know, these rights are the right to erasure. It's like the right to be forgotten in any situation. The right to portability, which I think the last person on stage talked a bit about portability, and the right to restrictive processing. Now, these three human rights, specific to humans and the digital evidence of their personhood, which we can define further, in American language come down to one central word that really resonates with us most, and that's ownership. I want to have total agency over my digital footprint, regardless of who controls it. I want to be able to call out flagrant or fraudulent actors, regardless of who controls a copy of my data, because, not just because I'm concerned about my privacy, but I'm also concerned about my value in a given situation. And so, as we all submitted literature for articles of the GDPR, we saw these 99 articles come together to establish what we all hold now as legislative precedents for agency in the digital age, in the age of knowing, or beyond the information age. But as a proper American, I care about markets. I care about markets because they're efficient. I care about markets influencing government. I care about government. I definitely care about government. I'm not a libertarian. But I care about markets giving multiple perspectives about the value of a thing. Now, new language that's starting to happen in the world in general, not just in the United States, is as data as different things. And we see it in the news, we see it in magazines. People talk about data as an asset class. People talk about data as property, because we can give people ownership of property. People talk about data as labor, especially organized labor. They're talking a lot about data as labor now, because they're specifically thinking about the economic divide between the haves and the have-nots, so the people who contribute data well, the low-risk people, and the people who don't, the high-risk people. When I say risk, I'm speaking specifically about how insurance might identify risks. So while each of these scenarios may be true, they don't cover the gambit. They all don't hold up in every situation. There's a large debate going on, especially with actors here in the UK that are specific to organized labor, like Uni Global Union, who some of you may know, who think that the idea of data ownership is dangerous, because if you give people legal ownership of their data, you think about discrimination in a market, like a very wealthy person just buying up as much of an individual as they possibly can. And so I think it is necessary to establish that the language ownership is really just specific to agency. This is more marketing of how we're going to communicate in the United States per what we understand. So privacy, it doesn't go very far in the United States. Not in the same way that it does here, as you all, or at least the 28 actors, including the UK, pre-Brexit, endeavored to legislate privacy as a human right. And if you talk to most lawyers, I think that they would agree that it is not possible to do that, to legislate privacy itself as a human right. But we should consider how people are talking about data, because it becomes very important when we want the general public, even people who run companies, middle management up to executive level, how they understand what data is. Data as an asset, data as labor, data as property. The cool thing is, per data being something that we do want people to have the ability to own, it's rigidly written into the GDPR. There are about 11 of those 99 articles which we submitted on that talk about data just specific to the employee standpoint. So the GDPR is, again, a lot of you know, talks about not only consumer data, but also talks about employee data. And that's really important to us at the Data Union because we're not just thinking about privacy across the board. We're not just thinking about the right to erasure, portability, and restrictive processing across the board. We're mainly thinking about scenarios where, for instance, so I'm an economist by trade. I was an engineer first, a mechanical engineer. So we just think about process. But mainly my focus is the process with which productivity happens. And everyone for the past 600 years has established productivity plainly as a measure of inputs. And so the real thinking behind the GDPR, the compromise beyond what governments wanted and their ability to be able to tax large companies that run amok, is the ability to write into law your ownership of your input to my economic productivity. So if you are an employee, to run through a scenario at company X, and let's just say you're a project manager, you don't build products, et cetera, you just lead a project down the road to succession, and that project is productive for whatever reason. There are many players who have poured into that project. They've been paid a wage, which we normally call a retainer for your time, but all those people are paid a wage and incentivized to come to the table, and they give an input to this overall productive thing. It's either a product or a service. Companies only grow through projects or products. As that service or physical thing or software, which is not a physical thing, become productive, it is necessary to be able to point to what of that productivity am I owed as an individual. And per the GDPR, you're allowed to legally now advocate for what you may be owed from productivity. And so in a scenario where you do leverage the right to portability or the right to erasure from your company, say, you know what, I'm leaving, I'm going to a new company, I want you to erase everything, every email that I sent, et cetera, and you have that right. The company also has the right to counter-sue and say, well, your input is the integrity to our intellectual property, which can be a truth. As it is, as you have those sort of three eyes lining up, it's really the argument that you want them to make. You want to say, well, I'm still leaving. And whether you delete my stuff or not, you need to send me my just due. Because the way process engineers work, and when I started my career, we go service company by service company. I'm not talking about robotics here. And we map out what everyone does every day. And we use processes like Lean Six Sigma and things like that. For you all who aren't familiar, it's a process engineer's dream. And as we bring this into play, we throw software on top of it. We'll take your proverbial 2 hands and we turn them into 200. But by the time we get rid of, get to those 202nd pair of hands, we likely get rid of you. We hire some 20-year-old for a contract fee to oversee the job, and we pay them significantly less. And in doing that, we've seen a large income inequality gap grow. These are statistics from the United States, but it's applicable everywhere. We see it across the EU, we see it in Asia, we see it in South America, we see it in Africa, we see it everywhere, and in other cases, it's a much wider gap. These are statistics from the Bureau of Labor Statistics, but it is necessary to say, as people talk about on this stage, about data portability, and they talk about data as just a commodity or just an asset class, it is not just that. I think we'll have a panel right after this, and we'll talk about cross-border communication of data. And the interesting piece in that is data is not a rival good. Data is what economists call a non-rival good, meaning it can be consumed by multiple parties at once. So even while you may take my input to create a productive process or product, it can also be used in a million other places at once. And it's still mine. It's still mine per the GDPR, and it's still mine per the sorts of laws that we're going to write in the United States. Now, our real objective here, again, is to establish the value of this in a market-based way so that we can indemnify people. And I use that word indemnify because it really means getting folks paid for their use without their complete consent, complete knowledge, their complete participation. This is an inclusion argument. This is about how do we get people to participate in the increasingly autonomous internet of everything and the increasingly automated economy. And the GDPR, even though it's been a good decade in the making, on the heels of old policies from the late 90s, it's the first step in doing that. And so our real objective here is to establish that this non-rival good cannot be wholly or solely owned by another entity. There will always be a negotiation in play. If for no other reason, then we're going to be able to litigate it to the nines. And that really is the play. I heard somebody else mention earlier how the United States is thinking about the GDPR, and it is thinking about the GDPR. There are multiple commissions that have been propped up in the last few months, some before May 25th. But we've actually passed data protection laws in a few states so far. And when I say we, I mean the data union specifically. The majority of my time is spent in the airport arguing with commissioners across the states about these policies popping up. We just passed something in California that allows people to sue up into an amount of about $750 in small claims court. And the reason it is such a small number is because organized labor pushed this law, and they're looking to create a tidal wave of litigation around flagrant and fraudulent use of data. But most people can't afford to sue you outside a small claims court, which is really about $5,000 or less in the United States. We've got new stuff coming out of Colorado. Ohio just passed a Data Protection Act. This was about 4 weeks ago. South Carolina, these aren't just liberal northern states. South Carolina just passed the Insurance Personal Data Protection Act about 2 weeks ago. New York has a baby version of the GDPR that's just specific to financial services. And so we're gearing up and thinking about this topic, but there is some uniqueness to the United States because of our adoption of at least the idea of free markets, even though, it's a constant negotiation and nothing is always free, and sure, there are always government support, subsidies of sorts. But our First Amendment is, in my opinion, the first barrier to things like the right to erasure. And think back to earlier, I established personal data as everything that disseminates from you and everything derived about you. So while you do have the right to insist that information that disseminated from you per your publication should be erased, you do not have the right in the United States, per the First Amendment, to get rid of what I think about you. And that's really important for markets because most markets are built on the idea of arbitrage, meaning multiple people may value similar assets in different ways over time, and usually for financial folks, you're playing both sides and you want to see the price come together to get a more normalized price. But in the case of arbitrage from a cultural standpoint, we always want two or more actors saying what a thing is, what it's worth, how it's established, how we establish it in caucus. And so the right to erasure, your total autonomy about ideas about you alone is not something that we will honor per the First Amendment in the United States. I mean, we just won't be able to write it in the law and enforce it. Any judge that understands the Constitution will go, well, we have a First Amendment, so you can't just say that, I think James is ugly, and so we're going to render him that way, period, across the board on dating apps. And so he gets lower ratings. I mean, assuming that that's even a scenario, which it is not. But so to push that even further along, we have political candidates who are thinking about data as a natural resource in the same way we would oil, et cetera, who are going to run presidential campaigns in the next 2 years. They're already running them right now. This guy started a group called Venture for America, and he's running for U.S. president based on the idea that he can establish a patrimony for participation in the economy in general. Most people will call that a basic income. Just by a show of hands, are you all familiar with the concept of basic income? A few people are. So basic income, or universal basic income, it's a 500-year-old concept that just says people should get a check, should get some compensation for their participation in a society, in an economy, you name it. This particular version of it is a market-based version of it that's based on data. So when the last presidential election ended in 2016, Hillary Clinton, who lost, she wrote a book called What Happened. And in that book, somewhere, I didn't read the book, but I did watch an interview that a journalist named Ezra Klein did with her. Ezra Klein runs a company called Vox, VOX.com. He did an interview with her, and he said, Hillary, can we talk about the most interesting thing to me about your book? She said, hit me. So he actually said, you almost ran your campaign based on universal basic income, but you didn't. Why didn't you? She said, well, I looked at the oil patrimony that we have in Alaska. So if you didn't know, Everyone who lives in Alaska, they get a check every month based on the oil that we extract from the ground in Alaska. She said, I couldn't figure out how to make that patrimony work in the other 49 states, so we did it. And she wanted to be able to defend whatever her loose claims were. Now, the majority of us who are already on a data binge understood that the valuations of every single company, publicly traded or not, are based on the valuations of the data that they have, period. Every company is a data company, not just the FANGs, but if you establish a valuation of your company just based on the insurance contracts that you have on your top executives. Let's say, you have a chief US economist for Standard & Poor's. She went to Harvard. When she says stuff about the markets, whether she's right or wrong, it changes. You take out a non-compete contract on her based on her trade secrets. And per those trade secrets, you say, we want to insure her plus 20 million bucks. That company is worth at least 20 million bucks, but they probably have that across the board with multiple types of entities. In the United States, we can divide personal data into 5 regulatory categories. There's insurance, there's finance, there's healthcare, which is the big one in my opinion. There's IoT, which we're starting to see fade away, that we would have put Facebook, et cetera, into. And then there's telecom, your location-based data. Across those 5 regulatory categories, we can establish personal data being leveraged to fuel every single company on the planet, whether we realize it or not. And we can leverage that in these new laws like the GDPR to start to pull some of that value back. So I am an advocate for the idea that data is a natural resource. I think the CEO of IBM uses that language a lot right now. How am I doing? Oh, I got time. Oh, we're done. Okay, so I got to end. Beyond the idea, really quick, for 2 seconds, beyond that idea, I want to say, so we've made some progress. If anyone is familiar with the Cantera initiative, which is here in the UK, there are plenty of consent policies and ways that we operate our businesses that are already in play. The GDPR is an add-on to that. It establishes a universal framework for us to identify and indemnify people. But it is necessary to note that we establish personal data as something that is a representation of your personhood. It is not just a commodity. It is not just labor. It is not just policy. It's not just an asset class. And until we adopt sort of universal standards, ideas around what our digital identities are and what our digital lives are, we will always be susceptible to manipulation. But as soon as we get past that, because it's pretty easy to do, we're in a much better place. And I think that's where we're going. Again, we're very proud of the GDPR and how it's come together. And we look to blow past that in the United States and look at broader constitutional policies around digital agency so that we can start to leverage it to not only protect people's privacy, but to indemnify people. Thank you.